Hold up. This is a classic move in the legal world, opting for a plea deal to avoid a heavier charge. If he had stuck with the original charge, it could have been a felony assault, which comes with some serious consequences. But by pleading no contest and going for deferred adjudication, he's hoping to avoid a conviction, essentially betting on a second chance. It's risky, but he's rolling the dice.
Dunning, can I have parties announced for the record for the state defense?
Ricardo Briones for Mr. Christopher Dunning.
And are you Christopher Dunning?
Yes, ma'am. Yes, Your Honor.
We're here for sentencing. You entered a plea of no contest and applied for deferred adjudication on May 13th. According to your plea bargain agreement, the state proceeded on the lesser included offense of assault, bodily injury, family as a Class A misdemeanor, and the state recommended deferred adjudication. All right, and we're here. Thank you.
Notice how the defense is already in position Ricardo Briones is, representing Christopher. And if you're wondering about the formality of this, it's pretty standard procedure to make sure everyone knows who's involved in the case from the start. This step is critical for the record.
We're here for sentencing. Any witnesses, defense?
Yes, Your Honor. I believe Lori Dunning is in the courthouse, in the courtroom. I would like to call her as a witness.
All right, Ms. Dunning, if you'll come forward.
Hello. Good afternoon,
Good
Your Honor.
afternoon. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
It's Lori Lynn Dunning.
All right. Defense, it's your witness.
Thank you, Your Honor. Lori, can you spell your first name for the court reporter?
Yes, it's Lori,
And you go by Lori Lynn. It's your middle name?
and is my middle name, Lynn.
And Ms. Dunning, what is your relation to Chris Dunning?
He's my husband.
And were you the complainant in this case?
Yes.
Okay. And as you know, the court agreed to give him deferred adjudication probation.
Yes.
Are you in agreement that he can have contact with you?
Yes. Yes, I am.
Okay. Right now, generally, these things are given a no contact order. Are you asking the court today to modify that to a no harmful?
Together since 2000, right after 9/11, it's 2001, but we've gotten married in 2004.
And as far as you know, you haven't filed for divorce. You want to continue being in a relationship with him, correct?
Correct. That's right.
And you would like him to be able to do his community supervision at y'all's residence, correct?
That's correct.
Great. I pass the witness, Your Honor.
All right. So do y'all have any children in the household?
No, we have no children.
All right. So you said y'all were married, but when did you first meet him?
It was right after 9/11, so 2001.
And so this physical abuse that happened, is that the first time?
Yes.
All right. So what caused it?
I believe our marriage was not in the best shape. Both of us, I think, had become complacent and just weren't taking care of each other ourselves. And I think he was dealing with some mental health issues. We're both nurses, so I could identify what I thought was maybe some bipolar issues that, based on my inattention maybe to the marriage, I think it threw him into some paranoia and behaviors that he's never exhibited before.
All right. I understand that you're saying that there were things that were happening in the marriage or things that you were going through.
Mm-hmm.
I don't understand how it escalated though to what I read in the police report.
It was just a various accumulation, I think I disconnected and went through a lot. And that took him into a state of, he felt I was leaving and like taking everything, and I think he lost control. So he was seeing his life fall apart right there.
So, because it became very violent from what I'm reading. And so I understand that maybe things are happening in the marriage, and I can't force people to do counseling, because for counseling, you need two people. And part of the conditions that I set is supposed to be conditions to protect all parties involved. And I know you're an adult, he's an adult, but sometimes as an adult, we have to be protected from ourselves. And what I can tell you is what I will do is he needs some treatment under his belt before I allow him to have contact with you. And when I say treatment under his belt, I mean he needs to do some violence courses. I know the agreement that you made with the family violence prosecutors were to reduce this, but it's saying that he choked you. And you know, choking somebody where they're having problems breathing, that's very up close and personal. And it's not something, from what I'm reading in the police report, it's not something.
The judge is laying it down here, no shortcuts. He's making sure Christopher gets the treatment he needs, especially because we're talking about something as dangerous as choking. The emotional weight of what happened isn't lost on the judge, but the focus is on reform, accountability, and making sure this doesn't happen again.
Something where you're doing something from a distance. That's sort of like up close and personal. And then you have to hold it for a while for somebody not to be able to breathe. So I'm not trying to destroy your marriage. Sometimes people have to go through their marriage and go for it as long as they want to. But I need to just make sure that he has some classes or something where he can internalize what his role in this was, right? I know you're saying that you had a role to play in this as well, but I'm only here for the fact that in anger. And so I need to make sure that he receives the counseling that he needs, because otherwise this relationship is not going to work anyway. Because whatever issues you all had before he got to this point, those issues still exist. It's just that you all have not been discussing them because he's in custody at the Bexar County Jail. So what I find in cases like this, individuals need to work on themselves. While I'm forcing him to work on himself, you need to work on yourself as an individual. Then once everybody, you and he both, are able to look at your relationship objectively and see if this is a relationship that truly should continue or not.
Oh man, this is a tricky moment. Lori is advocating for less restrictive conditions for her husband, but let's not forget victim input is important. But the judge's primary job is to keep the victim safe. The judge's hands are tied here legally. It's like a tug of war between emotions and the law, and he's got to prioritize safety.
You'll be in a better position to make that determination. So for now, I'm not going to allow any contact. He can come back in 3 months. By then, he should have done some classes, because I'm going to order the batterers intervention prevention classes for him. And he's shaking his head over there upset now. So that tells me he needs to be in some classes, because he's not internalizing and he doesn't understand the reason why we're here is because he choked you. And the reason why this is reduced to a Class A misdemeanor, I'm sure it's because maybe you didn't want to come in and testify. And the state is still trying maybe to protect you by having some form of probation for him. So that's where we are. I'm not going to allow contact. That's where we are.
May I say?
Sure.
Okay, so the incident I know was over a year ago.
Wait a minute, this is a critical moment. Lori says she agrees on counseling, but here's the catch. Counseling doesn't magically fix things. The real question is whether both of them will put in the effort to address the issues that led to this situation in the first place. 3 months? That's a short time for some real change. Can Christopher make that mental shift? Time will. Tell Doc.
For his reasons, had a bond out and didn't turn himself in. So we have been living together for the last year with no incidences or fear that I fear from him. And I think that says a lot. I do agree on the counseling for both of us and him.
Here's the thing. It's 3 months for him to start classes. Neither of us are teenagers here. It's not like, oh my gosh, it's 3 months. It's the end of the world. It's 3 months. As we can tell, time goes by quickly. Heck, it's almost Christmas. And that's come around very quick. We're almost about to be into 2025. And what I can tell you, what I have discovered sometimes, people are on their best behavior when they have cases pending. And you know why they're on their best behavior when they have cases pending? Because they don't want to go back to jail. And sometimes, and we can go off the record, sometimes I've been.
And now we have the final ruling. Deferred adjudication means no conviction as long as he follows the rules. But here's the kicker. The judge is still keeping the pressure on. BIT classes, no contact with Lori, and reporting. And regularly. This is a last chance to get things right. Will Christopher follow through or will he slip up?
A defense attorney. And I've represented people who've been charged, both males and females, with being violent with their partner. And you know what I would always tell them? You had better be the nicest person you can be. You had better get your life in order. Here's some counseling. Would they take that advice? Sometimes they would, sometimes they wouldn't. My only job was to represent them and get them a favorable outcome. And you know what ended up happening? 9 times out of 10, maybe 2 years later, I get a phone call. They're charged with another assault case against the same person or either against someone else. And you know why that's the case? Because when you have charges that are pending, whatever the issue was that made them be violent, it hasn't gone anywhere. It's just sitting in the closet waiting for itself to come out. All right? All right. But thank you so much for coming in, okay?
Thank you.
All right, we can go back on the record. This is what the court is going to order. The court is going to place you on 2 years deferred adjudication. There's an affirmative finding of family violence. I'm going to order the BIP.
Wait a second. SSI, head injury. Classic case of someone navigating complex systems. If you're unfamiliar with SSI, it stands for Supplemental Security Income, basically a lifeline for people with disabilities. But here's the catch. It's not just about the injury. This court is all about making sure there's proof and follow through. If you're looking for a reality check on the bureaucracy of these benefits, this is it.
P course. There's to be no contact with Lori, Lori, Dunning, until further notice, and probation. Once he has completed, been in the BIP course for at least 3 months, you can always come back and the court will reconsider. There's to be regular reporting by Zoom or in person. There's to be regular random UAs, proof of employment within 30 days.
I'm disabled.
Pardon?
I'm disabled.
All right, just a second. Proof of employment within 30 days or proof of SSI. What's your disability?
Head injury.
All right, proof of SSI within 30 days. If not, there's to be no employment as a home health care provider or with minors. And just a second. I'm going to want field visits 1 time per month. It's to be random. And so for the first 3 months, 1 time per month.
80 hours of community service. OR pays $7.25 per hour to charity. Oh, the good old pay-to-play option where your wallet might be the key to redeeming yourself. But let's not ignore the fact that this court is balancing empathy with the law. Community service is a chance to give back. How much do you think that could shift someone's mindset?
And then thereafter to be random, but no less than 1 visit every 3 months. There is to be 80 hours of community service restitution. He can either do the 80 hours of community service restitution, or I'll allow him to pay $7.25 per hour to a charity of his choice. It can either be, and we'll do a referral to Center for Healthcare Services, or if he has his own personal doctor, he can go to his personal doctor. Probation, is there anything else that's needed? All right, is there anything else you need from the court in order to be successful? Sir, is there anything else you need from the court?
Well, I have to go back to jail.
No, you'll be released. You just cannot live with your wife.
Okay.
All right. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Did you catch that? The judge is reading the defendant like a book here. It's not just about the event, it's about understanding a pattern of behavior. When it comes to family violence, the stakes are high, and the law doesn't forget. This is a sharp reminder. How many people can truly recognize when a simple conflict becomes a dangerous pattern?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am. I have a question.
Yes.
Where do I go? I don't have any family or anywhere to go.
You can go to Haven for Hope. You can go to Lifetime Recovery.
Is that across the street? Do you have directions?
Oh, their probation will let you know where it's located at.
And will they provide me with counseling?
Yes.
Thank you.
All right, you're welcome. Charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes.
And if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison. Did you understand?
Yes.
Plea bargain agreement. State is proceeding on count 1. State will remain silent on your application for deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Miranda. Second, did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
It is the plea.
State is at the plea. Remain silent on your application for deferred adjudication.
Okay, here we go. The judge is explaining the plea deal, but there's a bit of legal drama going on. If the defendant doesn't get deferred adjudication, we're talking up to 20 years in prison. Did you hear that? 20 years. So the real question is, what kind of mental gymnastics does a defendant need to perform when facing the unknown of deferred versus straight? Time? That's a huge gamble.
There's an affirmative finding of family violence. There's to be no contact with Miranda Medellin, no contact with Renee Vasquez II. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
It is the plea.
State is at the plea.
Yes, Judge.
With an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition.
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your
We need
And outside the
Sorry,
agreement,
Your Honor, I need to just put
Yes.
down, that issue of family violence needed to be addressed. Motion.
Yes, Your Honor, we would like to orally strike, and we can do it on paper.
The plot thickens. Let's break this down. Deferred adjudication is like a second chance, but it's not a get-out-of-jail-free card. If this person messes up, those 20 years could come crashing down. So, here's the big question. Do you think the risk of future punishment is enough to change someone's behavior today? It's like walking on a tightrope over a pit of lava.
First of all, the affirmative finding, Your Honor.
all right, so here's the thing with the affirmative finding of family violence. I need to put you on notice what that means. Now, I will read through the police reports, and if it's a family violence matter, then I'm going to find there's an affirmative finding of family violence. But if it's not, then I won't make that finding. Does everyone understand?
Understood.
Yes, Your
All
Honor.
right. So outside the agreement, in the event that I do not grant your application for deferred adjudication, the state is going to recommend that your punishment be set capped at 4 years in the prison. Did you understand that would just be a recommendation from the state, and the court would not have to follow that recommendation?
Yes, Your Honor.
So do you understand that if the court does not grant your application for deferred adjudication, the court could sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Okay. Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No contact.
And Judge, that's not how I'm sorry this plea has gotten so cumbersome. The cap, there was supposed to be a cap of 4 years, so you could sentence her from 2 to 4 years.
No. Y'all are not allowed to tell the court if she's applying for deferred adjudication how much I can sentence her to if I don't follow your agreement. I'll take it in consideration if I were not not agreement. Your plea bargain.
And here we are, wrapping up the legal tango. The court's making it crystal clear. If this application for deferred adjudication fails, expect the full weight of the law to drop. The reality is harsh, and that sentence could be anywhere between 2 and 20 years. Let's hear it for transparency in the courtroom, though. Can you imagine what's going through their head right now?
Is that the state is to remain silent on your application for deferred. So what that means is the state is not going to tell me that they don't want you to have deferred. They're not going to tell me that they do want you to have deferred. Hypothetically, if I were to grant your application for deferred adjudication, the state can make a recommendation and say, Judge, we want her in deferred adjudication for 6 years. I could say, well, no, I'm only giving her 4. I still will have followed your plea bargain agreement. Or, oh, well, I'm giving her 8 years deferred adjudication. I will still have followed your plea agreement. The suggestion that your sentence be a cap of 4, that's not a part of your plea agreement. The part of the outside the agreement is, if I do not grant your application for deferred adjudication, then the state will ask that you be sentenced to no more than 4 years. But I don't have to sentence you to 4 years. I could sentence you to more than 4 years. Am I going to do that? I don't know. Am I going to grant your application for deferred adjudication? I don't know, because I'm going to need a PSI report. So that's the agreement. And if people don't understand that as agreement and want to withdraw, you're more than welcome to withdraw. But as far as the state's recommendation of a cap of 4 years, if you don't receive deferred adjudication, that's just something for me to consider, but I don't necessarily have to follow that.
Understood. We'll still go forward.
All right. So does everyone understand that if the court were not to grant the application for deferred adjudication, that I could potentially sentence you up to 20 years in prison? Do you understand that?
Yes, Your Honor.
Do you understand that the fact that the state would perhaps recommend or will recommend a cap of 4 if I don't grant your application for deferred adjudication, that's just something for the court to consider. Do you understand?
Yes, Your Honor.
And do you understand that if I were not to grant your application for deferred adjudication and the state were to recommend that you be sentenced to 2 years, 3 years, or 4 years, and I decided to sentence you to 10 years, that will not have violated your plea bargain agreement. Do you understand?
Yes, Your Honor.
All right.